And so one of the things I was asked to present on today is what the legal definition of capacity is. And so if you think of it this way, the way that everything is set up, in our system is when you turn 18, you become an adult. And what that really means is when you're an adult, you inherit all of these abilities to do certain things for yourself without the interference of other people. Now, one thing when I'm speaking to parents who have children, minor children who are disabled, and even severely disabled, something that's not inherently understood and not um, really something that those families are thinking about is that their severely disabled child, once they turn 18, becomes an adult. So there's nothing in the law that says just because you have a certain diagnosis, you are not an adult and you are not able to act as an adult. And so a lot of the planning for those families includes the realization that, hey, when my child turns 18, I as a parent lose the ability to handle their affairs. So if you think about parents with children, parents kind of take for granted and get used to this natural right to I'm in charge of signing my kid up for school. I'm in charge of signing my kid up for any programs they're involved in. Whether or not the child wants to be part of it or not, the parent gets the final say. Well, all that changes once somebody turns the age of 18. And so there is a necessary legal process that the parents have to go to when their disabled child turns 18 to regain those rights that they had as parents. And we'll talk about that legal process towards the end of my presentation. Guardianship and conservatorship are the words that we use in Utah to explain those legal appointments to make decisions for another adult. And so adulthood starting in this country in our system at age 18, that's when that triggers. So when we're talking about people who are born with disabilities, or we're talking about people who were independent functioning adults until they contracted something like a dementia or another condition that starts to affect their capacity, that's when those legal processes come into play. When we're talking about the definition of capacity, the answer is it depends in what context we're talking about. And I've listed four different very common um, different sorts of capacity that we deal with regularly in day-to-day life. The first ability, and these all have intersections with decision making for people with disabilities. So, first thing is the capacity to contract. So, if you think about it, when you're 18, you can go and buy a car, you can sign your own financing agreement, and your parents, theoretically, if you qualified, do not need to be on the loan with you or be involved in that transaction. You are considered at age 18 to have the capacity to contract. So that means, entering into contracts for business purposes, entering into other sorts of contracts such as marriage. Okay, so marriage is a topic that frequently comes up when we're talking about caring with people for people with disabilities. So in Utah, a person has the capacity to contract if they are 18 years or older and have sufficient mental ability to understand the nature and consequences of the transaction. Minors and individuals who are mentally incapacitated may lack contractual capacity, making contracts void or voidable. Now, looking at this definition, this is not a very hard bar to reach. You don't have to be someone with a super high IQ and have everything figured out to be able to contract. All you need to do under Utah law is to be of age and to be able to understand what you're doing and what the consequences of what you're doing are. Now, you'll notice that, you know, people who are mentally incapacitated may lack contractual capacity, but it does not say do lack contractual capacity. So that's a really important distinction. And you'll notice with all of these definitions we're going to talk about, the definitions are wiggly, right? Because there are some people that have a certain diagnosis who can do some things and can't do other things. If you think about somebody with Down syndrome, for example, there are varying levels of the severity of that Down syndrome. You have some folks with Down syndrome who are very much able to participate in decision making and be involved in how their lives are shaped. And there are some that are just very severely disabled and need somebody to arrange everything for them. So you're never going to find a definition of capacity that says if you have this diagnosis, or this diagnosis, you are de facto unable to do something. You're always going to find that there's some wiggly definitions. Now, this can create some problems in trying to manage care for people with disability. And I'll give you one example of a client, an actual client that came to me for help with specifically this capacity to contract issue. She had been taking care of her elderly mother who was diagnosed with Alzheimer's disease. She had not gone to court to get guardianship. She had just arranged her life in order to help her mother. She had moved her mother into the house next door to her, so they lived right next door. She would bring her food. She was going over there frequently to check on her. She was helping her do her medications. So she had created what she felt was a safe bubble. Well, unbeknownst to her, one day a moving truck pulls up to her mom's house and starts to unload a baby grand piano into the house. And my client is sitting there looking out the window like, what in the world? They must be at the wrong house. Well, it turns out that her mother, unbeknownst to her, had been having this delusion in her kind of as a result of her cognitive disability that had caused her to think that she had a boyfriend who was a famous piano player. So mom didn't play piano, but in mom's mind, her boyfriend played piano, and it was really important that she got a piano. So she had gotten a newspaper one day in the mail and had seen an ad from this company selling pianos and had called them on the phone and ordered a baby grand piano on the credit card. Okay. So we eventually were able to undo that transaction due to the incapacity. However, we did have to go to court with that company and prove that at the time that piano was ordered, mom was not able to understand the nature and consequences of the transaction. And that was very clear when you actually spoke to mom at length about why she got the piano and she didn't understand kind of how money worked and things like that. So now, if the daughter, and again, we'll talk further about guardianship and conservatorship in a few minutes, but if the daughter would have gone to court and become the guardian, depending on the language of that court order, if she had a full guardianship and conservatorship, then her mother would have been stripped of the ability to enter into contracts. And so when I talk to clients about what they should do, how they should prepare, I mention this as kind of a cautionary tale of you may still run into issues, even if you think you've created kind of a safe bubble, if you allow your disabled adult to continue to have decision-making authority. It may cause some hassles. And again, these things are all wiggly and we don't have the crystal ball to be able to tell if there's going to be problems that come up, but it is definitely something to be aware of. The other thing I want to mention on this topic is about marriage. So marriage is a contract in the law. Okay, so this is the bar, this is the qualification, this definition of whether somebody should be allowed to get married. And it is considered a human right for each of us to associate with the people we want to associate with, even having those romantic relationships with other people. Now, that can get a little bit, it can make caregivers and guardians kind of sweat because, and I'll tell you from personal experience, we have some clients who want to have sexual or marital relationships with other people. And so we are not able to just simply say, no, you can't do that. You're under my control and I'm not allowing you to associate with this person. So now you have to dive into whether the client has the understanding of the consequences of what they're doing. And when you're dealing with people with disabilities, you also are looking at whether their partner has sufficient cover or whether there might be a risk of one or both of them being exploited by the other, right? So that's another tough part of this is maybe my client is very, very disabled and has expressed that she wants to have a sexual relationship, but her partner is much, much less disabled, and there might be an element of my client being taken advantage of. There's also risk of pregnancy. There's also risk of different things having to do with consent, having to do with sexual assault, having to do with STDs and diseases. And so it is quite a process to actually look at and understand what's happening, making sure that everybody is protected, right? Because the caregiver or the guardian is ultimately in charge of making sure the person has the flexibility in their life to do what they want, but is also being kept safe and secure. And so these marital or sexual relationships are definitely one of the trickier ones to navigate. But again, underscoring the fact that these individuals do have the human right to associate and have those relationships, and that should not just be taken away because they have some sort of a disability. And so you've kind of seen, maybe if you've watched some of the shows that take you behind the scenes of maybe Love on the Spectrum or the shows about the folks with Down syndrome that are seeking love. You can very much see that in play when the parents in those situations are really stressing about their child and whether they're going to be safe and but at the same time trying to help them have a fulfilling life. So that is one big context of this capacity to contract. And again, later on in life, and we just had this happen with one of our individuals who, the folks that get dementia or Alzheimer's at end of life, it's actually a very common scenario that when they are living in an assisted living or a facility environment, that they will meet somebody there and maybe want to get married. And with folks in that situation, there might be financial things that you need to consider. How do I keep this person financially safe from the person that they are trying to marry? Is my person going to be safe in this situation? So it can be quite a situation to navigate. Another capacity that we talk about in the law a lot is a capacity, what's called testamentary capacity. Now, this is important when we're talking about estate planning or completing documents to appoint individuals to act in fiduciary roles. So, all of us are presumed to have testamentary capacity at 18. But when a lawyer meets with a client, let's say even this, maybe this becomes the most applicable when we're talking about older folks with dementia or Alzheimer's disease. Somebody might have gotten a diagnosis of dementia and is wanting to get their documents into place. And so they go and meet with an attorney, and it would be incumbent upon the attorney to make sure that the person that they're speaking to has testamentary capacity. Again, this doesn't mean they have to be completely, hitting on all cylinders. It just means that under Utah law, that the person is of sound mind, meaning they understand the nature of the documents that they are completing, whether it's a power of attorney, a will, or a trust, whether they understand what their property picture is. So if this person understands what he owns and can voice to me who he wants to have inherit those items of property after his death, um, and he understands that the documents that we're completing, um, makes these gifts after he dies, then that's really all, we would have to have in place in order to complete these documents. Um, and so again, we see a lot of litigation and disputes happening in the court about, between maybe siblings when their parents pass away because there's an allegation, oh, you took mom to the attorney and had this will done, and this will favors you, or the will isn't how I thought it would be. And so a lot of those disputes center around whether the person had testamentary capacity at the time that they created the documents. So there's a reason why there's two witnesses to a will that's necessary and a notary public for a fully properly executed will, because that gives three individual witnesses to the signing of the document who have had an opportunity to talk to the person and can testify to whether or not they're capable. Um, so you can see that the best move would be to complete your estate planning documents in an attorney's office, because if you're simply printing off the documents and signing them at home, a lot of times you don't have those impartial witnesses. Maybe you're using your kids as witnesses, maybe you're using people with a bias, right? So that's something that I talk to people a lot as well. So testamentary capacity can still be present if somebody has a dementia or an Alzheimer's disease, as long as they can understand these four prongs of the definition of testamentary capacity. Another one we won't talk about too much, except for it does correspond somewhat with people with disabilities, is criminal capacity. Criminal capacity just involves, again, a wiggly definition of, did this person have the mental state required to commit the crime? So that's going to be very crime specific. So if the crime requires intent, so, first degree murder, right? First degree murder requires that somebody actually planned and pre-planned this murder and then carried out the murder, right? So there's a different intent there than there would be to a negligent manslaughter crime where somebody maybe hit someone with a car or something. There's a different level of intent. So that's going to be very crime specific. Now, where this corresponds with people with disabilities is that people with disabilities can and often do commit crimes. We've got a segment of our clientele who are young adults who were born with disabilities, and the nature of their disabilities makes them very erratic, makes them have behavioral issues, makes them maybe antisocial, or makes them just essentially not fit well into systems. Another scenario that I have that comes up quite a bit is concerned family members that call me about family members who are essentially homeless due to their combination of their own decision making and some mental deficiencies. And the conversation there is um, it's always difficult because, well, for one thing, unless everyone should know that prison or jail is not a good place for somebody who needs treatment for cognitive disorders. Really, what it is it's a holding cell to keep this person away from other people. But in that prison system, unless they're sentenced to go to an actual hospital, they're not going to be receiving medical care and rehabilitation that works specifically with how to address their behavioral issues that are caused by an intellectual disability or a frontotemporal dementia or something like that. And so we do have some tragic situations where we have clients who commit violence with their roommates at the group home. They're unable to work through their frustration, and it comes out in physical violence. Those clients unfortunately end up kind of ping-ponging around, going back and forth to jail as they re-offend. The jail ultimately releases them because they are not safe to be in the jail, and then they come back to the group home and they're not safe to be in the group home. So that can really create a big issue, and it is something that I think that ultimately the state of Utah is going to have to address how we handle folks like that. We do have a campus in American Fork. It's called the Developmental Utah State Developmental Center. That is our only state kind of run um, facility, inpatient facility for challenging adults, disabled adults with challenging behavior. That is a campus that is closed and very well staffed, where we have a lot of clients reside who can't otherwise fit into other community settings. But we probably need more facilities or campuses like that, because this is something that can happen. So criminal capacity is definitely something that can intersect. And even if the person is unable to maybe balance their checkbook or do other things, they may be deemed to have had the requisite intent or mental state to commit a crime. And that creates a very weird intersection of the criminal system with capacity. And then finally, in leading me into a discussion about what we do to help people make decisions, is the definition of incapacity, which is applicable in a guardianship context, or a context where we are trying to determine whether someone should be able to continue being in charge of their own life, is kind of the broad way to say this. So, under Utah guardianship law, an incapacitated person is generally someone who, due to mental illness, intellectual disability, physical illness, chronic substance abuse, or other cause, lacks sufficient understanding or ability to make or communicate responsible personal decisions. So again, another wiggly definition. You're not going to see, hey, if you have dementia, you're automatically incapacitated. But if the person with a diagnosis or another condition starts to demonstrate that they lack sufficient understanding or ability to make their personal decisions, now we get into this realm of, does this person need a guardian? Um, and there are several contexts where that person might need a guardian. One might be that you have a child who was born incapacitated and is just going to always need help. They have, even with going to school and the other therapies that are available, they're just never going to be able to obtain the skills necessary to balance the checkbook, make a wage, not be exploited financially, right? That's a big thing that happens if somebody doesn't understand what money is and they just give their money to other people. That is something that puts them at financial risk. The other thing would be that the child that you've been raising is just not going to be able to understand medically what's going on with them and what the smart medical decision might be. That person is going to need a guardian to step in and um, and be the person to make a decision. So when we talk about guardianship and conservatorship, we're really talking, the best analogy is to think about a parent. Getting back those rights that a parent would have over a child, to talk to doctors, to make decisions, to get this person enrolled in different programs, to manage money, to make sure that person's food and shelter is paid for, all of the different prongs of what it takes to take care of somebody. And, so when we're talking about guardianship, we are actually talking about a possible range of different decision-making abilities that a court can remove from a disabled person and give to somebody else to make decisions on their behalf. And that context can be broad, it can be everything. That's called a full guardianship or a plenary guardianship, where this person has been deemed disabled to the point where we need this person to be appointed to care for them in total. So this person has full guardianship. The other option is what's called a partial or a limited guardianship, where that person says, well, maybe this person has demonstrated that they're fully capable of making medical decisions and taking care of their physical needs, but they're starting to lack the ability to manage money. And this is commonly seen in the folks in the older elderly age group when they have lived their life as a healthy adult. They get dementia or Alzheimer's disease, and then certain things start to slip, right? So a lot of times one of the first things that slips is just losing track of the bills they need to pay, or just not understanding that, I'm not supposed to give the landscaper $1,000. It's only supposed to be $100. Or, hey, my friend asked for money, and so just gave them money, and I gave them a lot of money, which doesn't make sense in the context of my budget and what I'm able to afford. So those things start to slip. Going back to the clip, the ability to drive. That is an ability that is a contract capacity question, intersected with whether or not the person can pass the requisite testing. And so maybe somebody is starting to become a danger to themselves or others on the road, and so those decisions lack. So maybe we just need limited powers given by the court to help this other person in a very limited capacity. Um, I'm going to skip over some of this. I want to kind of talk about guardianship and conservatorship before we talk about the estate planning stuff. Um, so so when somebody decides that they want to become someone's guardian or conservator, and let me explain what those terms mean. Guardianship and conservatorship are the terms that the state of Utah uses to describe two pillars of responsibilities. Guardianship means the care of the person. That's going to cover medical, shelter, food, medication, just taking care of the person's physical well-being. That's guardianship. Conservatorship, on the other hand, is taking care of the person's financial assets, bill pay, talking to the financial advisor, making investment decisions. That is considered a separate pillar in Utah. Some states use guardianship as a term for everything. Some states use completely different words, but in Utah, we have these two different pillars. Um, Sometimes I get people that call my office that say, I'm the guardian for my sister, but I need help with something. And I say, okay, well, are you really the guardian? Because sometimes people use the word guardian, and what they mean is they're the person that's taking care of the person. But in reality, in order for somebody to claim that they're the guardian or conservator, they actually need to be court appointed by a judge to do those roles. So, in order for that to be accurate, they would have had to go to court to get that appointment. Now, think of it this way. So, all of us here are in charge of their own decision making. We have our bank accounts, we're able to do things. In the Constitution of the United States, we are guaranteed liberty rights. So, we have the liberty to do certain things. So guardianship and conservatorship are actually pretty serious legal cases, because what you're ultimately seeking to do is remove somebody's constitutional right to their own liberty and transfer it to somebody else. So imagine how you would feel if somebody went to court and got appointed as your conservator, and now you've lost all access to your bank accounts, and now somebody else gets to make all the financial decisions for you. It's a very drastic power that the court is granting when it's granting guardianship and conservatorship powers. And so they take it very seriously. And so the process of a guardianship is always going to be through the court. And there are certain things that most states, including the state of Utah, will require for a guardianship to be granted. One important one is that the disabled person, the person alleged to be incapacitated, must have their own attorney. And this is not like a public defender kind of thing. This is a privately paid attorney that gets appointed to represent the disabled person in the court hearing. And so not only is there going to be an attorney, or if the family is not filing with an attorney, that petition gets filed by the people that are seeking to be guardian and conservator. but there's also going to be an attorney that participates to advise the person alleged to be incapacitated about what this is. Like, do you realize that by letting your daughter be your guardian, you're no longer going to have a say in what surgeries you have, right? That the doctor can simply call up your daughter and your daughter is going to dictate what happens to your physical body. Or do you understand that by your daughter becoming conservator, that you are going to lose the ability to manage your own bank account, right? And a lot of times, and I've been an attorney for the person alleged to be incapacitated many times, and a lot of times those conversations are very obvious, meaning the person has severe dementia and they really aren't even understanding what you're saying to them. You sit down with the paperwork with them and you're looking through and you're saying, is so and so your daughter? And how would you feel if so and so was able to make these decisions? And the person may not even have the ability to have a conversation with you, right? Then the attorney in that situation is going to go to court and tell the judge that based on my observations, I attempted to review everything with them. This person just simply didn't understand, and it would be my recommendation that this person have a guardian. Those are the easy guardianship situations. The harder guardianship conversations always center around somebody who is being an obstacle to their own safety, right? So somebody doesn't have dementia or another disability to the point where they're completely out of it, but they are either clinging to independence if they're an older person, right? And they're saying, heck no, I don't want my daughter involved in this. I don't. But daughter has lots of police reports and different things to show that dad is really not doing a good job caring for himself. And so what happens is that attorney for dad has to present that objection to the judge and say, Judge, he doesn't want a guardian. He doesn't think he needs one. Okay. And so now the family is put into a position of having to prove to the judge that even though dad doesn't want a guardian, there is plenty of evidence to show that he lacks that sufficient capacity to understand what he's doing and to keep himself safe. And so those can be rough cases because it can cause some family dysfunction. It can cause some angst to have to go to court and say that your parents are failing and they need help and if your parents don't want to hear that and if they're trying to really fight against that, that's going to be a harder case. It's still definitely doable, but the court's going to make everyone go through the process of proving those because again, the constitutional right to liberty is so strong that the court really is going to be careful with how they dole out that responsibility. Guardians and conservators are obliged through the course of their guardianship and conservatorship to file annual reports with the court. So the court supervises the guardianship and conservatorship. The court reviews financial statements. The court reviews, basically, the guardian fills out a report every year that says where the person's living, what their current medical diagnosis is, what their medication list is like. And so this gives the court the opportunity to trace financial activity throughout the course of the conservatorship and to also just kind of keep tabs on what's happening, making sure that somebody doesn't just go into court, get a guardianship, and then leave court and take all of somebody's property and get out of there. So that's the intent of that reporting requirement, and that is a safeguard to help keep the person safe. So essentially when we're talking about what can we do for ourselves or what can we help our clients understand is the biggest thing that you can do to plan for some of these unexpected and unknown things like dementia, Alzheimer's disease, or even planning for one of your children who might have a disability. The best thing we can do without having a crystal ball is to make sure that we've got a good estate plan in place. So let's just talk about for ourselves. So sitting here today, I don't have any idea that whether or not I'm going to end up with dementia or Alzheimer's disease. I can get some clues from family history. I can get some clues from lifestyle decisions, things like that. But other than that, it's really, I don't know. I hope not. I hope I don't. But if I did, the best thing that I can do for myself is have an estate plan in place because all of these documents, when we're talking about a trust, a will, a healthcare power of attorney, or a financial power of attorney, these documents are documents that I get to elect the people that I trust to take care of my finances and that I trust to take care of my healthcare decisions. If I do not have documents in place, it places certain members of my family on equal priority with the court. So, for example, if I had children, all of my children would become equally able to apply to be my guardian. And maybe I'm in a situation where I trust one of my kids more than I do the rest, or one of them's kind of irresponsible and I don't want them around the money. So I need to have these documents in place so that I can maintain as much control as I can over who eventually is placed in a position to take care of me. So that's what I tell people. We don't have the crystal ball, but we do have the ability to get documents. In the Utah Healthcare Power of Attorney, it's called the Utah Advanced Healthcare Directive, which is a state form. If you Google Utah Advanced Healthcare Directive, it's going to come up. It's a free form you can print out from the internet. There is a place where you get to say, I want this person to be my guardian if I ever need one. You also get to make your end of life support decisions. You get to make legally binding end of life decisions that your guardian will not have a choice but to fulfill. And so that's a really powerful document to have in place when it comes to guardianship and conservatorship. And then just, I know I'm running out of time. I just want to briefly touch on special needs trusts, or otherwise known as supplemental needs trusts. When we're talking to specifically people who are have a disabled child and they're trying to plan for the child's future, that's one of the scariest positions to be in. Is I've got a disabled child, I've been taking care of them my whole life. They're now an adult, I'm still taking care of them. What happens to my special needs child, adult child, who is disabled after I die? Right? Because I've had it locked down, I've kept this person safe, and now I'm going to be gone. Who's going to do that? That, especially that situation, they need to do an estate plan. They need to have that all outlined. And if they plan to leave money to their disabled child, they need to do it properly in a way that's not going to disqualify them from different government programs that are income and asset dependent. So, in other words, if I have my child on SSI or different housing benefits or food stamps to help them buy groceries, and I die and I leave them $200,000 in my will, that's going to disqualify them from all those income-based programs. So in order to leave them money for their support, we have to do it through a special trust, and we appoint one of our family members to manage that money for the disabled child's benefit. So there are certain strategies to utilize so that we preserve benefits for the disabled person. So with that, I'll just end my presentation there, and facilitators can let me know if there are any questions.